Hey, welcome again. Now, page 5 and page 6 of our purchase agreement. Number 34, FIRPTA, Foreign Investment in Real Property Tax Act. FIRPTA for short. The parties to this transaction acknowledge that they are bound by the requirements of FIRPTA and that the required addendum or affidavit shall be prepared and executed to determine the amount required to be withheld from a foreign seller's proceeds, if any. Now, I'm going to address it here that what they're referring to here goes back to the listing agreement. So whenever you're representing a seller, there's a question as to whether or not they are a United States citizen, which then gets to the point, are you a legal resident? Do you have a green card? There will be exceptions to it, but be alerted to FIRPTA. And that if you have someone who is not a legal United States citizen, then contact one, your managing broker, two, your title company, and find out exactly what is going to be necessary to be able to take care of this and make sure there's no surprises at the time of closing. Paragraph 35, simply stating it's a binding document, people. Y'all acknowledge that they have been advised to consult an attorney, and you should, to protect their interest in this transaction. Is it necessary? Well, it's necessary that we tell them they could and should. What do 99% of them not do? Seek an attorney. I will tell you that attorneys, they're a necessary evil, and we just got to have them because they're great when they're on our side and have our back. It's no fun when you're on the other side, but they are there to take care of people. Where the transaction involves financial and tax consequences, the parties acknowledge that they have been advised to seek the advice of their accountant or financial advisor. So a statement that really we should all get used to using is simply, Mr. and Mrs. Seller or Mr. and Mrs. Buyer, I am not an attorney, and I will not provide legal guidance. Now, if it does deal with finances, Mr. and Mrs. Seller, Mr. and Mrs. Buyer, I am not a CPA, I'm not a financial advisor. As such, here's what you should do. Cover your backside, folks. Number 36 is the disclaimer. From us as the brokers, us as agents, in that broker and broker's agents specifically disclaim responsibility for the condition of the property. It is not us to provide you with this guidance or information. Now, be careful that you're not providing anything that you shouldn't be. And or the performance of the agreement by the parties. Parties acknowledge that they are not relying on any representation or warranties that may have been made other than those that are in writing. And the parties waive and release and relinquish any and all claims of causes of action against the brokers, their officers, directors, employees, and or their agents for the condition of the property or the performance of this agreement by the parties. We haven't got anything to do with whether or not people can or do complete the process of this agreement, is what it's saying. Brokers and its agents are not experts in the areas of law, tax, financing, surveying, structural conditions, hazardous conditions, or engineering, and buyers acknowledge that buyers have been advised to seek professional advice from the experts in these areas. Guys, we sell real estate. We are experts at marketing. We are experts at negotiating, putting people together. Got a buyer who wants to buy, a seller who wants to sell. Get out of the way and put the two parties together so that each ends up happy at the time of closing. That's what this is all about. It is important for you to know, and this is pretty much a standard on all purchase agreements, regarding a final walkthrough prior to the closing. And it's just simply, plain language, buyer reserves the right to walk through the property within 48 hours prior to closing to determine whether the terms of this agreement have been met. Is the property in the condition that it was when we wrote this offer and it was accepted? Are there things missing? Guys, I would tell you, do your walkthrough the day of and preferably right before the closing. It has happened to where things are missing, such as furnaces and air conditioning units. Makes a big difference. All right? Let's see. The agreement supersedes any and all understandings and agreements and constitutes the entire agreement between the parties, and no oral representations or statements shall be considered a part hereof. Handshakes and verbal agreements in real estate are not legally binding. This is more or less telling them that. Time is of the essence, guys. In real estate, time is of the essence is very, very prevalent. We don't wait to get things in to be presented. We don't wait until the next morning. Anything can happen. A minute can make a difference between somebody getting a property or not getting a property. So 39, time is of the essence, states buyers and sellers understand that no extensions of the times contained herein are expected or agreed to unless specified in writing and signed by both parties, buyers and sellers. Time is of the essence. So guys, often it's you to remind them and not to forget yourself that you need to get things moving as an agent. Don't delay in getting things presented or accepted. Successors and assigns, standard verbiage. This agreement shall bind personal representatives, administrators, successors, and assigns of the parties. It's a binding agreement. Becomes the bottom line. There's no walking away from it for any reason other than what the purchase agreement allows. Now, this is just brought up to today's really digital world. And that's where facsimile, most of us would know that as a fax. But really, we're talking electronic authority and digital signatures. So this is important. Here's what we know about having a binding agreement. If you will, gang, we have offer, we have acceptance, and then the third part to that is delivery. Offer, acceptance, delivery. Upon delivery, we have a meeting of the minds, a binding agreement. Now, understanding that as an alternative to physical delivery, here's the paper. The parties agree that this agreement, any amendment or modification of this agreement, and or any written notice of communication in connection with this agreement may be delivered to the sellers in the care of the listing agent and the buyers in care of the selling agent via electronic mail or by facsimile, via the contact information set forth above. Offer, acceptance, send an email, binding agreement. It's that simple. That's what it says. Well, let's keep going on. Any such communication shall be delivered at the time it is sent or transmitted. Seller represents and warns that an electronic email address has been provided to the listing agent from which sellers may receive electronic mail. Buyers represent and warrant that an electronic email has been provided to the selling agent from the buyer's agent may receive electronic mail. The parties agree that the electronic signatures and initials shall be deemed to be valid and binding upon the parties as if the original signatures or initials were present in the document in the handwriting of each party. All electronic means of signatures or initials by any party must be accompanied by a certificate. So guys, any of the digital signing applications that we use, SkySlope being the common and preferred method, will be legally binding because it has the certificates. All right. Arbitration. Let me read this and then I'll give you the strategy, the philosophy behind this and how we may handle this. Any dispute over the disposition of the earnest money deposits or claims arising out of or related to the physical condition of any property covered by this agreement, included without limitation claims of fraud, misrepresentation, warranty, and negligence, shall be settled in accordance with the rules then in effect adopted by the endorsed provider of arbitration services for the Michigan Realtors. That's a lot of stuff that runs on and on. But it says, if you're going to do arbitration, this is what you're going to agree to do. It's a voluntary agreement between the buyer and the seller. But failure to agree to arbitrate does not affect the validity of the agreement. So if the buyer said, yes, we'll arbitrate, but the sellers don't, and you can see it's agreeing here by initialing, if one does and the other doesn't, well, it doesn't mean they can't arbitrate at a later date. They could still do that. A judgment of any circuit court shall be rendered on the award or determination made pursuant to this agreement. This agreement is specifically made subject to and incorporates the provisions of the Michigan Uniform Arbitration Act, Michigan Circuit Law, I think is what that stands for anyway. This agreement is enforceable only as to parties and brokers, agents who have agreed to arbitrate as acknowledged by their initials below. The terms of this paragraph shall survive closing. Otherwise, just because things happen afterward, you're still agreeing to arbitrate if you agreed to do it here. Now, Darwin, what should we do? I'm going to give you what I did with one of my mentors years back. And I said, Tom, what's your thoughts on how we should guide people with whether to agree in advance to arbitration? And he said to me that, well, probably the best way to give you my thought is to ask you a question. That question was this: why would you ever waive your right to a juried trial? Well, you see, that landed to me, I hope, the same way it landed with you. You see, I can always agree to arbitrate later, but if I agree to arbitrate, I can't go to a judicial court later. Arbitration would be the agreement and what I would have to do. Hopefully that helps you out. Bottom line is I don't know that anybody should, but I'm not going to tell them they should, not going to tell them they shouldn't. But I'm going to ask them that great question so that they can make that up on their own. Number 43, it's all the miscellaneous stuff. It says if we're going to alter, amend, modify, or otherwise change any part of this agreement, it needs to be done in writing between the two parties. It's got to be on something in writing signed by both parties. It's called an amendment. I'm amending the first 5 letters, amend the contract. Headings. It says, headings contained in this agreement are there for reference purposes only, shall not affect in any way the meaning or interpretation of this agreement. Just a convenience thing. It's where we can go to be able to find things quickly and then find out what the terms of the agreement are actually saying. Grammar and syntax. Well, that used in this agreement shall be construed to give proper meaning and consistency to its content. Thus, or means and or. The singular may be construed to include the plural, the singular, and the use of any gender or tense may be construed to include all genders and tenses. If I say buyer or buyers, it's the same thing. Plural or singular. Same thing with seller, sellers. He means she, or any other definition that may come out with the way that the market is changing, governing law. This agreement shall be governed by and construed according to the laws of the state of Michigan, the state in which the property is located. And we're only going to be able to do this in Michigan. That's the only place that we're licensed, unless if you have a license somewhere else in some other state. So guys, that's page 5, and page 6 really brings it down to the simplistic finalization. We're going to disclose basically the agency so that we can identify what the supervisory broker is doing and what their agency relationship to the parties may be. So the parties hereby acknowledge that the seller and broker and salespersons are agents of, most of the time we're only going to be checking off the buyer. But if I happen to be selling another Coldwell Banker listing, Coldwell Banker Professionals listing to be clear, then that's in-house, and we now have that I represent the buyer, but there's another agent who's representing the seller. That's where both would be checked and representing. You see, we could have, let's make it real clear, an agent who represents the seller, but that agent does not represent the buyer. So they are the agent. We have both sides. We're handling both sides. We're going to check both off. If we personally have both sides, we're checking both of these. But I may only be representing one or the other. But here's another scenario, so follow me on this one. I may be writing again on another Coldwell Banker. Now, substitute Century 21 Professionals if you are with Century 21. I represent the buyer. The other agent represents the seller. Now they're both designated. Both are representing, therefore, the buyers, both buyers and sellers. So this is it an in-house transaction? These first two boxes. The second is, who's being represented? Is it the buyer or the seller, or is it both buyer and seller? Let me cover it one more time. Is it in-house that we have both the buyer and the seller? In-house. We have both sides, buyer, seller. Do we represent only one or the other? Or do we represent both buyer and seller? You see, here's the reason. If we represent both buyer and seller, then all supervisory brokers, not you, the individual agent, they are acting as disclosed dual agents of both the buyer and the seller. It's what this whole paragraph is about, is making a disclosure that the supervisory broker may be acting as a disclosed dual agent. Make sure you complete this correctly. Paragraph 45, there for you to be able to add any additional clauses. If you're using Transaction Desk or the preferred sky slope you will find clauses when you click in this section in those applications. Those clauses is what we would prefer that you use and not write your own. Guys, keep yourselves out of the courts. Keep us out of the courts. Keep your buyers and sellers out of the courts. Don't write your own clauses. Use those that exist. Make sure you complete this section. This offer will expire on, at, and we specify the time. How much time do I give? Not long. Not long. What do I mean by that? I would tell you in most circumstances, no more than 24 hours. There are exceptions, but I don't want to give people the thought that they have more time and can wait for other offers to come in. We all know that state law says that we will present all offers as soon as possible. Now, if the sellers are giving them direction to wait, different story. But I only want to give them 24 hours to respond. Or less. Again, there's exceptions, but that's what I want to give you as a guideline for what you would put in here. Obviously, the buyers are going to sign. The question is, if you're doing this digitally, do I witness it? The answer is no. You didn't see them sign it. You didn't witness them signing it unless you're signing it in front of them. If they're signing it, let me rephrase that, signing it in front of you, then you could witness it. But if I'm sending this electronically, I know to whom's email addresses that I forwarded this to. But did that actual individual sign it? You don't know. You didn't see it. So don't sign as a witness unless you've actually seen them do it. Now here's what we give on our purchase agreement for people to do. We want them to check that it is accepted as written, and then they would sign. Or they would go, it's subject to the following changes. Now they may go through and make all the changes on everything prior to, but we're giving them space to actually put the counteroffer right in this portion of the agreement. At that point, preferably, they would check this, put those specifics in here, and then they would give us a time because they've rejected the offer. They've made an offer. We call it a counter offer. They've made an offer to what we originally offered, and they're giving us until, just like what we did, a specific time and date to be able to respond, and you can see, or until it's withdrawn in writing, because up until there is a delivery of acceptance, they can be withdrawn. At that point, seller signs. Hopefully we have an easy one, and we're just accepting or acknowledging the acceptance or accepting the seller's counteroffer. It is as simple as it sounds. Guys, there's your initials again. It's on all 6 pages. Hopefully that brought some clarity, some understanding as to how to complete the purchase agreement. And there's so many more things that we could do, but this is really just an introduction to the HRC Realty purchase agreement. We'll see you around. Have a great one.